To order, if we could ask Chairman Walker to lead us in prayer.
Bow with me, please. Heavenly Father, we lift you up this afternoon and ask for your guidance and grace and mercy. Give us wisdom and discernment as we make decisions for Georgians. Keep us safe and bless our families. In Christ's name we pray, amen.
Thank you, Senator Walker. Good. We have 4 bills on for today, and then we're meeting tomorrow at 4 o'clock. 4 o'clock, right? 4 o'clock, and we have 4 bills on. And tomorrow, as you know, we convene on Thursday at 10 a.m. We have to have all bills in by that Thursday morning time frame. So my thoughts are is we're going to finish up with these few bills, and the calendar will most likely not change unless we may delete a bill if the criteria that I've said has not been made. So we got 4 good bills today, and Chair Lady Cooper is leading the charge here with House Bill 605, and we're looking at LC 338801S. And the floor is yours, and we do have a few people to speak, and we'll limit testimony today, but the floor is yours, and you're not limited. So there you go. There you go.
Thank you, Mr. Chairman and members of the committee. I bring you House Bill, the substitute to House Bill 605, and as I said when I presented it in the House chamber from the floor, it was a work in progress, basically, and that we would be making changes. And those changes have been made. Due to the pandemic, the one thing that we have learned from that is how families are concerned about their loved ones in our nursing and long-term care facilities. And, in many cases, people haven't seen their families for a year. And so 605 is ensuring families and facilities communicate openly and transparently when installing video, audio cameras in residence room while protecting the privacies of roommates. It's core to me in this bill that it's about patient protection, protecting the privacy, the mental well-being, and the privacy rights of our seniors. I've looked at 13 other states when working on this bill, and I've worked with the stakeholders, including the ombudsman, the elder care facility community, the prosecuting attorneys, and the representatives from the Georgia trial lawyers have not come to me, but they have worked with the lawyers for the nursing home. So I have not worked directly with them. It's been lawyer to lawyer. As like with the trial lawyers, they gave us 7 things they wanted changed, and those 7 things were included in the bill. And before I take you through the bill, I want to address one thing head on. As many of you know, Mr. Dempsey, who passed away in a very, very traumatic way in a nursing home, the Dempsey criminal case went all the way to the Supreme Court. And there have been, and Mr. Dempsey's son is with us today. I just met him. The trial lawyers have brought him, and I'm sure he will testify. There have been some questions as whether this bill prevents Georgia families, like the family of Mr. Dempsey, from placing a hidden camera in the room of their loved one if they have security concerns or suspect criminal activity. The answer is quite simply no. Criminal prosecution using footage from a hidden camera placed by a resident for security concerns is explicitly in this bill. It's one of the changes that occurred after it came over from the House. But we should not want simply to catch the bad actors after harm is done. We want to prevent harm from occurring in the first place. I'm a nurse. I'm a healthcare and a senior advocate. I've worked on senior bills for the last 10 or 15 years here in the thing. I want to prevent bad care that leads to accidents. And that's what open surveillance does. I mean, there is plenty of research. Think about police using body cameras now. They're out in the open. They protect the people that the police are dealing with, but they also protect the policemen to see if they did something wrong. The use of cameras in classrooms, cheating goes down. And these are open cameras, out in the open. Open cameras change behavior. I really want to see the camera, where we would have cameras in every room. It would be the norm, not the exception. I mean, I can watch, when my puppy was alive, and she passed away this summer, I could watch my corgi at any time in doggy daycare. Family members watch their children in child care facilities. We also, a few years ago, voted to put cameras, open cameras, in the classroom of our children with special needs. This was a state law. So that is what I'm doing. This is a policy. Many of the things in this bill, we make policy decisions here. And I would hope that we would want to foster the open cameras while still having the provision in a criminal case if somebody fears for their safety. Would you like me to walk it, just sort of a brief thing of the lines through? Okay, all right. If you look, then lines, starting on line 34, it requires a written consent form from both the resident and any roommates prior to placement of an electronic monitoring device. The consent form allows them to request that the device stay on 24/7. This is something that the state ombudsman want. If a family member or the resident wants the camera on 24 hours a day, they check that box, and it's to stay on 24 hours a day. But we also, respecting the privacy of our seniors, put on a couple of boxes where there could be exceptions to that. This covers not only nursing homes, but it covers assisted living facilities. And a resident may not want the camera on while they're taking a bath, or other personal care is being performed, or when they have a visit from an intimate partner, can't say it. And also there is a fill-in-the-blank one where they can write any exception that they want. We address the concerns with patient decision-making capacity in lines 22 and 23 and lines 71 and 75, which allows the consent to be signed by someone other than the patient when that person lacks decision-making authority. Lines 80 to 81 provides that devices placed in accordance with this law should be placed in an open and obvious location, and we require visible signage. So outside the room, there would be a sign that there's a camera in that room. Take notice, give your best. That's what, cameras do. They help people remember to do their best, and it changes their behavior. But at the request of the Prosecuting Attorney's Council, we clarify in lines 256 and 259 that any recordings derived from a camera, hidden or otherwise, which was placed by the resident out of security concerns, may still be used in any criminal proceedings. This language explicitly preserves the right of a resident as to surveil their room under Section 6-11-62(2) of the Georgia Code, and for law enforcement to use any recordings derived from the surveillance. We address practical issues from what happens if roommates disagree on monitoring, lines 86 to 93, to access to the internet, lines 98 to 102, to repair the facility for damage caused by installation lines. There are practical issues that do occur. And so, who's going to pay for the internet session? If it's one person and one patient that had a camera using an internet, that would be one thing. But hopefully, you'll have almost everyone with a camera or some kind of an internet connection, and then the home would make the decision probably to have them pay for that service. At lines 136 to 139, we make it clear that an electronic monitoring device may not be hampered or obstructed in any way without the consent of the resident, and a facility may only move or adjust an electronic monitoring device to return it to the position authorized by the resident in the consent form. For example, if it was turned toward a non-consenting roommate by a housekeeping staff member, the staff could turn it back toward the resident. If, so the roommate doesn't want to be filmed, they would have the right to turn it back as with a consent form. Importantly, we do not alter the rules of civil procedures and evidence in considering the admissibility of any recordings from cameras installed in accordance with this bill. But we do require sharing of the video captured by an open camera with the facility upon request if a demand letter is sent or a complaint is filed. We have clarified that residents do not have a duty to maintain the recording except following written request to do so by the facility arising out of an allegation of harm. Hopefully, once these are the norm, if a family member thinks something is not quite right or their loved one is not getting all the attention they should, they would share just the recordings with the facility so that they could work on improving the care being delivered. As is standard in these bills, in lines 172 to 175, we provide that facilities shall not be responsible for violations of rights of privacy associated with video monitoring, and conversely, a facility may not discriminate against a resident for using a monitoring device. In lines 251 to 254, we clarify that the consent form will be maintained on the DCH website to ensure that the timely access to the form for families. And then there have been questions about enforcement of the law. One of the things that some of the advocates wanted was for DCH to make rules and regs for the putting this law into use. However, the facility people that work with DCH have informed me that they already have the laws that will cover these. Section 31-2-8 already provides for civil money fines of up to $2,000 per day for code violations, among other sanctions, which can be imposed upon a facility by DCH. And I think we have somebody from DCH that's willing to testify to that. In other words, if all of a sudden the family complains because somebody is turning off the camera quite a few times during a day or several days in a row, if they filed a complaint with the department, that would, according to the department, be interfering with the care of that patient, and they could impose the fines. So to conclude, this is a compromise bill. It provides an easy-to-follow process for families to openly place an electronic monitor in the room of a family member in an elder care facility. It addresses and protects the rights of residents and roommates, addressing mental competency and privacy rights. It addresses several practical matters like cost and installation, and it addresses the use of the recordings obtained without altering or restricting the admissibility of recordings obtained from open cameras in a court of law, and preserves law enforcement's use of recordings in criminal proceedings like Mr. Dempsey's case. Like I said, I am a patient advocate. I've worked for patients the whole time I've been in the legislature, and I truly believe that when we get open and obvious cameras in our room, we will begin to see a difference in how satisfied our patients are, their families are, and they being able to communicate with them, and also in the quality of care. I do have samples of the wonderful things you now can get for barely over $100 or less of the kind of cameras that can be placed in patients' rooms and the communications devices. So this is not something that is astronomical or hard to do for a family to, keep a check and communications with their family members. And with that, Mr. Chairman, I'll answer any questions. And I have with me, since I am not a lawyer, and I felt that I really needed an independent lawyer helping me as I worked with all the different groups. I have Leah Aldrich with me, who is a healthcare attorney, and she may be able to answer if it's a legal question much better than I am.
Great, thank you. Does anybody have any questions for the chair lady? We have 9 people to testify, and we can do questions now, and we can do questions with the people who testify, and then we can circle back at the very end and have questions then. So, Dr. Al.
Thank you for presenting this bill. One quick question, and I don't know if it's addressed in the bill, I didn't see it, but does the bill stipulate for how long this footage, this surveillance footage is to be archived for reference, if we're talking about
No.
referring back for criminal cases or?
No, it doesn't, and they don't have to keep it unless it's been. They have in writing for the facility that they want to write it. That's right.
So the way I understand it is that it's not the facility's camera.
It's the patient's camera.
Right.
Okay, got it.
Okay. All right. Any other questions now? So let's do the testimony. We have 4 on Zoom. We got 5 in person. So I'm going to try to limit everybody to a couple of minutes and see if we can get some questions also. For GTLA, Mike Prieto. Did I pronounce that correctly? Prieto. Thank you. That sounds much better than I pronounced it also. We appreciate that.
Thank you, Mr. Chairman. My name is Mike Prieto, and although I am here on behalf of Georgia Trial Lawyers Association, I have focused my entire professional career in representing people who have been abused and neglected in nursing homes and assisted living facilities for over 25 years, or almost 25 years. I would like to respectfully submit that this bill attempts to fix a problem that doesn't exist in the state of Georgia. It requires permission from everyone in the residence room to sign consent for them to be recorded. That is the current state of the law in Georgia today. Today, all that Knuckles did was say that for purposes of a security exception, the Supreme Court recognized that the resident was also an occupier and therefore could avail themselves to that exception. So what this bill does respectfully is it makes it open and obvious, which you could do with consent anyway. And open cameras are a great thing. I would agree with Chairman Cooper. It will help residents. And so we're all for open cameras. But the open cameras itself is great, but what the bill really does is it overrules a lot of what Knuckles stood for. Because in many instances, in my 20-plus year career in doing this, you have law enforcement authorities who get a 2-hour block on elder justice issues when they receive their post-certification. They don't know what constitutes criminal acts versus a civil matter. And what my clients are repeatedly told is that it is a civil issue, it is a civil issue. And so you have many, many instances in which these horrible acts are not prosecuted, the police don't bring charges, and it's up to the civil judicial system to bring people to justice.
Thank you. Could you just clarify for me, Knuckles? I'm sorry. Was that the case?
Mr. Chairman, Knuckles is the case in which after the Dempsey matter aired from the media, the DA's office in DeKalb County decided to prosecute the care providers that were neglecting Mr. Dempsey.
I got you.
Correct.
From a criminal standpoint.
From a criminal standpoint.
And the civil case
Yes,
may
sir.
still be.
Yes, sir.
Okay.
And what you will learn, Mr. Chairman, is Mr. Dempsey's here, and he's going to tell you
He's
how
next on the list.
how he went to the police department and the medical examiner's
With
office
the film. Gotcha.
with the film to no redress whatsoever. And it was only after I became involved in it, because I represented Mr. Dempsey, that anything ever moved forward. So I think that it takes away a lot of the rights of the people that we're hoping to protect to give a free pass, because at the end of the day, all of our goals should be to let the truth come out.
And patience. Right. So does anybody have any questions for Mr. Prieto? Senator Kirkpatrick.
Question. I want to be sure I'm clear. The bill appears to address civil, criminal, and administrative actions on page 7.
Yes,
in
ma'am.
line.
And what the bill says is that if it's open and it is recorded pursuant to this statute, then it could be admissible. But what it really does is say these covert or hidden cameras are only admissible in criminal proceedings, and that, for example, the state of Georgia, if they want to assess a fine and they go before the administrative courts, they can't use it if it's a covert recording, which is contradictory to what the Supreme Court said was acceptable in the Knuckles case. If there was a civil matter, then it would not be admissible in court, in civil court either.
I appreciate that. Any other questions? 14?
Could you, where in the, have you got the bill with you?
No, ma'am, we were not provided a copy of the substitute. We'd asked for it, but they wouldn't give it to us.
Then I can't ask you to show me in the bill.
No, ma'am, I've never seen the substitute.
All right, so maybe we can circle back on that one with a later question. All right, Mr. Prieto, we certainly appreciate that. We have Mr. Dempsey here. Tim Dempsey, the floor is yours. And thank you for being here, and appreciate your travels. And if you wouldn't mind, we have a long day. We've been having a long day. If we can be direct and pointed,
Okay.
sure appreciate that. Thank you.
I appreciate you listening. My father was a veteran, and he was to go home the day that he passed away. We were told that he passed away in his sleep, and that they went to wake him up for breakfast, which we found out later was totally false. We would never knew that if it hadn't been for that camera in his room. That he'd asked me to stay there every night, and I told him I can't. I have to work. And sorry, but we put the camera there because things were happening, different things, some minor, some where somebody was rude or somebody came in his room, things disappeared. And we did this to where I told him, I said, I can't be here all the time, but I can hopefully, have some way of watching. Because he said when he tried to tell people that something happened, they didn't listen or didn't believe him. So that was the reasons we had put the camera in. And then, I get a call and says, oh, he passed away in his sleep. We went to wake him up for breakfast. And when I watched the video, I saw that was totally untrue. But, I called the police. I talked to the detectives that morning, and all the nursing home or the rehab center wanted me to do was just go ahead and call the ambulance and send him on to the funeral home. He hadn't even been pronounced by a doctor. And I got the runaround from basically the police department. I went to the coroner, and basically it was like, there's nothing we can do. Even after I watched the video, I went back and showed the coroner the video, and he went to get the records and a few things, but it took the civil lawsuit and the news media to ever get the district attorney or anything criminal to happen. That's why I disagree with this, where it can only be used in a criminal case. You should be able to use it in a civil case or even administrative to fine these people, because the only thing they're going to understand is fines or money or something, and to rule out civil lawsuits in a lot of this is basically walking backwards from what the Supreme Court had ruled that it was in, the video was in. And so I would like to see that change, that it could be used in civil and administrative issues also. I mean, the video is a non-partial witness, basically.
Mr. Dempsey, I appreciate that, and I've let you go over
All right.
time. And
Fine.
can you just tell me what happened in the Knuckles case?
Well, the case is still pending against them.
So they've been charged?
Oh, yes,
And this
but
was
it
just
it was
in,
just recent, I mean,
That's right, because this was in December, and I got you. Okay.
because,
So criminal charges are still pending?
yes, after the news media finally made such a
Okay.
big deal
And this
out
would
of it.
be, all right, you can, thank you so much.
All right, thank you.
Nancy Petro is next. Is she out in the home? Or Lance, Laurie, Watkins, and Laurie? You, Ms. Petro?
Yes.
Okay.
Can you hear me? Thank you, Chairman Watson and committee members. My name is Nancy Petra, and I am the Associate State Director of Advocacy for AARP Georgia. I want to thank Chairman Cooper before I start for her work on this bill. We appreciate the changes that have been made to the version that I believe you have before you from the House version. AARP has been a proponent and advocate for open visible cameras in long-term care facilities for several years. We have supported legislation before for this type of legislation, and you know, we're thankful that the Georgia Supreme Court ruling in December 2020 came along in the Knuckles v. State case to really spur this along. I do want to talk a little bit, though, about a couple of concerns that we still have with the legislation. In the latest version that I saw, which was LC 82S, I'm not sure if that's the one y'all are looking
Yeah, we're
at.
on LC 338801S.
Okay.
Okay.
Well, I'll make my points really quickly, and then if I'm wrong, y'all can let me. So we were hoping to see in Section 31-8-145 penalty language when a camera is intentionally and knowingly and willfully tampered or obstructed. Several states that have passed or considered electronic monitoring legislation have included criminal penalty language, including Illinois, Kansas, Oklahoma, Texas, and New Mexico, just to name a few. And then the exception at the end of the bill, the Section 31-8-149, I believe, where it talks about the admissibility of recordings, hidden recordings in criminal proceedings, which is the Knuckles v. State case exception. We're happy to see that that language is still in there. We would like to see that this be extended to civil and to administrative proceedings, because what Nichols v. State really said was, if a family member is fearful, so you feel that there's a security issue and you need to put in a hidden camera, so the open and visible cameras that are deterring the staff behavior, that are allowing family caregivers to check in, isn't doing enough. And if a family member at home says, you know what, I think something else is going on here, I need to put in a hidden camera. Knuckles says you can, and this part of the bill says you can. But it doesn't extend that admissibility piece to civil and to administrative proceedings, which we think are important for various things that Mr. Dempsey just talked about with his father's case and things that the trial lawyers will tell you about. We would just like to see that extended so that that protection is there for the residents and their families. We think that's a protection more for the facilities. So that's all I have to say. Thanks.
Thank you, Ms. Petra. Lance, Laurie? We can. We'll follow up.
Mr. Chairman, thank you. I'm Lance Lurie with the law firm of Watkins, Lurie, Rowland Chance. Just so we're 100% clear, we're not opposed to open cameras, okay? We would much rather prevent abuse than catch abusers. And I will be very brief, but I think it's worth pointing out, as others have, that the real problem we have with the bill is the bill makes it inadmissible if one does not have an open camera in compliance with the code section. And a couple of reasons, very briefly, that this is very important is in our practice, and like others, I've been representing neglected elderly people for almost 25 years, and I've seen all sorts of horrible things, many of which are caught on videotape, including rapes and people attacked by bugs. And often what's in dispute in these cases is what the defendant facility was doing about it. And often there is no criminal prosecution. And just to give you two very brief examples of what we see horrible cases of people developing pressure wounds that you could put a basketball inside of. And I'm not exaggerating. And in those cases, the fight is whether they were turning and repositioning the resident to prevent the pressure sores. And we are stuck with the testimony of their employees and what they record in the record. And when we see what's on a video, we will know what happened. In other words, the facility gets to create the record to say what they did, and they're often complaining about us, about our allegations, and they're saying, well, we were turning and repositioning the resident every 2 hours. And we're trying to prove they did not. And that's just one example. And a second example is we see residents that aren't fed. And they say, well, we did feed the resident.
Right.
And here's our record where we fed the resident. But if we had a...
Didn't match up.
It,
Thank you.
exactly. And so my point is that we would like to see it admissible in civil cases.
I understand.
And many families may come and not know about this statute and may not know that it has to be, they have to go through this process. And if they do put up an anti-cam, we believe it's their right to do so, and that evidence should be used as decided by a judge rather than the legislature. Thank you.
Thank you. And now online, we have Melanie McNeil. We have 4 people online. Melanie McNeil, Kathy Floyd, Joe Hood, and Brandy Sylvan. Department of Human Services first with Ms. McNeil.
Good afternoon, Mr. Chairman and members of the committee. I'm Melanie McNeil. I'm the State Long-Term Care Ombudsman. The Long-Term Care Ombudsman program is authorized under federal and state law to advocate, including public policy advocacy, for residents of long-term care facilities, including nursing homes, personal care homes, and assisted living communities. An electronic monitoring bill has been introduced several times in the last few years, and I raised concerns about all of them. This issue has lots of complications. But what I wanted to say today is with House Bill 605, I raised some concerns with Chairman Cooper, which she addressed, including first, making sure that each resident who has a phone, a computer, or other communication devices would be able to continue to have them and use them. In the original version of the bill, that wasn't necessarily the case. Not all residents have these devices, not all of them can afford them, but for those that do, we wanted to be sure that they could continue to use them. And they've been especially important during this year of pandemic when facilities have been virtually closed. Secondly, that a resident or his or her designated agent has the option to have 24-hour monitoring. And the purpose for that monitoring is for the resident and the family. It's not for others to be viewing, but it may be especially important for residents who have dementia, who may be restless at night or may try to get up when they shouldn't, or there may be other concerns about how the resident is interacting with other residents or staff. And thirdly, that when a resident has a roommate who's incapacitated and unable to give consent to electronic monitoring, that the facility provide information about how to contact the roommate's designated agent to be able to obtain consent. So Chairman Cooper made these changes and others for residents. I support the bill and I ask your favorable consideration.
Thank you, Ms. McNeil, and you went under your time of 2 minutes. We certainly appreciate that. The others will too.
I practice.
We're going to move on to Kathy Floyd with Georgia Council of Aging.
Thank you, Chairman Watson. I am Kathy Floyd, the Executive Director of the Georgia Council on Aging. First, I too want to thank Chairman Cooper for making changes to the bill. I know she's worked hard with the nursing home attorneys to craft a bill that they will agree to. It's especially important that this exception exists for criminal proceedings. But again, I would argue that it also be used for civil or administrative proceedings. One point that hasn't been made is that by only giving an exception for criminal, you're basically punishing the staff only, not the employer who is responsible for training and supervising them, which is what a civil proceeding would do. For these reasons, the council still has concerns about House Bill 605, especially considering for residents, a bill is not needed and we shouldn't rush to pass this bill. Thank you, Mr. Chairman.
Thank you, Ms. Flood. Now we have Joe Hood with DCH.
Thank you, Mr. Chairman. Chair Cooper had asked that the department come forward and give some testimony to clarify on the investigation of allegations related to a camera. Again, my name is Joe Hood. I'm with the Georgia Department of Community Health. I'm the Chief Compliance and Technology Officer, and I work with the Health Facility Regulation Division that oversees these facilities that are contained within the bill, which there are 3 primary ones: nursing homes, assisted living, and personal care homes. And so what I wanted to make certain that the committee was aware of is the department already has in place on the federal side for nursing homes through our contract with CMS and with the federal surveyor contract, the surveyors we have would go forward and they would investigate any complaint that came forward with the use of a camera. Most of those would probably be under the guise of emotional abuse or allegations of emotional abuse. If, for example, it was alleged a camera was turned and filmed a roommate inappropriately when they did not consent to that, or filmed a resident inappropriately when they'd asked for the camera to be turned off, then that would be something that, if that causes emotional harm or has the allegation of that, the department already has the ability to investigate that. Or of course, if there's physical harm or any type of allegation of abuse or neglect, we can investigate that today in the nursing homes under the federal guidance that we have, and in the assisted living and the personal care homes under the state rules and regulations. The department does not see an advantage to added rules and regulations because of the oversight that we already have, as was stated by Chair Cooper. The administration of the camera, as the committee can see, is thoughtfully explained in the bill and explicitly provided for. So there will really be no advantage to additional rules and regulations because we already have that oversight. And then lastly, I just wanted to explain and make sure the committee had the understanding. It would really be a challenge and a complexity to accommodate separate rules and regulations just for cameras, because then we would have the question of what are we following the federal rules in regards to nursing homes, where we have federally funded surveyors to go forward and investigate allegations of emotional neglect or emotional abuse or so forth, as we have today. If you had a cell phone and you did a picture, we would use that or investigate that in that manner. So it really would complicate things if those were added and we were asked to put that on top. So I just wanted to make sure that that was clear and assure the committee that the department can investigate the allegations of abuse or neglect that may arise from a camera.
Thank you.
I'm happy to answer any questions.
Thank you, Mr. Hood. We appreciate that. So let's continue to move on, then we'll circle back with questions since we're sort of pushed for time. Brandy Sylvan with DCH.
Hi, yes, good afternoon. Joe's made all the points that were necessary for the department. I don't have any additional points to make.
Okay, well, we'll save some time with some questions. And we have 2 more, Jenny Helms and Josh Belenfante, and then we'll do some questions from the committee, just in general from any witness, and then we can have Chair Lady Cooper. So is Jenny Helms here? Okay, Ms. Helms, the podium is, you're making your way. We appreciate that. Tell us who you're with and
Yes.
Thank you.
I'm Jenny Helms, president of Leading Age Georgia. We're the association for the not-for-profits that provide housing and services to older adults in Georgia. 95% of ours are faith-based, like Presbyterian Homes or the Methodists, both throughout the state, Lutheran Towers. Anyway, we're mostly faith-based, and we support this bill. And the reason we do is that our overarching goal is to help members create and maintain cultures of well-being for both the residents and the staff. And we feel that with all the work that Chairwoman Cooper has done on this bill, that it does protect the residents. We feel that the camera being out in the open will give the protection, and we feel that the cameras being out in the open will help create an environment that is needed for staff. Right now, the biggest challenge in long-term care is staffing shortage. And we need to do all we can to fortify the staff. And if we have hidden cameras, then we create an environment of distrust. And that can create somewhat of a harmful environment for them. So we feel that this bill is a very important bill that has a great balance, providing the well-being of the residents and the staff. Thank you.
Thank you, Ms. Holmes, and for what you do. We appreciate that. If you could just hang around, and we're going to have Josh Belinfante, and then we'll have questions.
Good afternoon, Mr. Chairman, members of the committee. I'm Josh Belinfante with the Robbins Firm. I'm an attorney in Georgia, and I'm working with the Georgia Healthcare Association, who supports this bill completely. I'll say this. You've heard a lot about why cameras are good. You've really not heard why hidden cameras uniquely are good. And so let me tell you the reasons why the bill strikes the proper balance and incents and provides a place for open and obvious cameras. It's because these are not rooms that are individuals alone. They have roommates. Those roommates, as you heard, may have intimate moments. They may have moments where their families are fighting about who gets to control what happens to that person in end-of-life decisions or with their assets. And we're not talking about just cameras with video that can be fixed. We're talking about audio as well. And that's why it strikes the right balance that recognizes the role those roommates have, and a lot of times physically, when you can't move them. The policy choice before you is really this. Do you want to have something that's open and obvious? There's a sign on the door so everyone that walks in there, whether it's a roommate, their family, a nurse, a doctor, a pastor, a lawyer, knows that camera's there and working? Or do you want to put a hidden camera and then try to resolve something after the fact? Prevention works. This bill puts the emphasis on prevention, and the criminal exception is still there. That was a request of the Prosecuting Attorney's Council. The chair agreed to it. We fully support it as well. Thank you.
Thank you, Ms. Belinfante. And we have one more person who wanted to testify, Mr. Skin Edge. I think he is out in the hall. And then we'll have some time for questioning. Here we go.
Thank you, Mr. Chairman, members of the committee. I appreciate the opportunity to come before you today. I'm Skin Edge here on behalf of the Georgia Senior Living Association. We represent a large collection of assisted living communities and personal care homes throughout the state of Georgia, and we are here to strongly support this bill. We very much appreciate the work that Chairwoman Cooper has done on this bill. This follows up on the great work she did last year on House Bill 987. She has been a true champion for our seniors throughout this state the last few years, or indeed her whole career. I think this is just another example of that, so we would urge your support of the bill. Be glad to answer any questions.
Yes, just 987 was the bill regulating assisted living facilities and personal care homes that I think went through Senator Calzert's committee.
Correct.
Regulated Industries, and passed out. So I thank you. I just want to make sure, because there are people in this room who were not here last year, and that's that's the way we are. So
yes, sir.
A lot of turnover here in the state capitol. All right, Mr. Edge, if you don't mind, just standing down, and I'd like
Yes,
to
sir.
open the floor up for questions, really to anyone who came up, and then I'd like to have closing by Chair Lady Cooper, and then we'll have the pleasure of the committee. Looks like Chairman Huffstetler, 13, lucky number 13, there you go.
Just a comment here from all the witnesses. I've heard a lot of those representing the owners that are talking about how they're going to protect the residents, but I haven't heard anybody representing the residents saying that they feel more protected by this, and so that's a little concerning to me.
So just in cameras in general, feeling as if they're protected more from that standpoint.
Right, I haven't had anybody representing the residents that they say they're protecting their intimate moments or whatever.
Oh, I see.
haven't heard
I got
anybody
you.
saying they're concerned on the resident side. It's only the businesses that are saying they're protecting them.
I got you, I understand. I guess the ombudsman, they were,
Yeah.
I would presume they would want to be protecting the intimate moments and so forth. I got you. I understand that's a good point, though. Number 7, Senator Dolezal.
Thank you, Mr. Chairman. This is a question for the sponsor bill, Chairlady Cooper. A couple of questions. First of all, I just want to understand, I want to make sure that I understand clearly what we are doing, or what your intent is with this bill. As I understand it, we're doing two things, and correct me if I'm wrong. We're allowing a pathway for residents to have cameras in their rooms in full visibility after an application process, if you will, notification process.
Correct.
In which everybody will know that the camera's in.
Right, and the recordings from those cameras can be used in administrative, civil, and criminal cases.
Okay, that was going to be a follow-up question that
Oh,
I had.
sorry.
No, you're good, you're good. I heard Mr. Pietro, I probably butchered your name, I apologize, Pietro, mention, and others mentioned that this would not be allowed to be used in civil. So can you please clarify that?
That would be from a hidden camera. And it gets to be, Senator, sort of a policy decision. Do we, to encourage the open cameras that can be used in civil, criminal, or administrative, and perhaps, hopefully, prevent bad outcomes like we've seen. Whereas a hidden camera is more of a gotcha moment. I mean, it's hidden, you know, you get it after the person is damaged or harmed, like Mr. Dempsey was. And so my thing is a policy decision, and I can tell you that, and I think the nursing home people will tell you, and the representative, that I won't use my nursing word, beaten them to death on what they wanted and what I wanted, and I won on trying to make this a middle of the road. I know that the trial lawyers like to go to court and would like it to be able to use it in civil cases, but it comes down, like Jenny Helms said, we have our state right now is paying for and providing 5,000 nursing assistants to work in these facilities. Part of it is COVID, but a lot of it is because it's very hard work. It's discouraging work sometimes, and they feel beaten up because we seem to think that all of them are out there mistreating the patients, and they're not. People who work in these nursing homes are lower paid, and most of them are doing a good job and taking care of our elders. But there's always a bad case, and the atmosphere is not good. And as much as I have ridden you weren't here about the bill last year where I went after and as much as I have moved bills on things, let me just say it. We need these facilities. I mean, what are we going to do, and where are our seniors going to go if, you know, they're sued all the time or always, you know, looking over their shoulder instead of working on education and doing their staff in trying to promote a sense of well-being, not only for their clients, but for their staff members. I mean,
I got you. We're running out of
I'm
time.
so
I think
sorry.
you have some follow-up questions there.
I'm sorry.
I do. So to recap, one, we're establishing a pathway for cameras in rooms. Two, it's your assertion, and I believe you can probably point to us, that can be used in civil cases. My third question I want to clarify, can you help me understand what this bill does for hidden cameras? Are you...
For hidden cameras,
Yes.
right. If a person fears for their safety or think, you know, that their family can put a hidden camera in. They could also have the one going that's, you know, out in the open, but they can put a hidden camera in. And if they find evidence that the person has been harmed, and that reaches civil things, then it can be used in the civil suit and by police. It's just not used in administrative, in this bill, or in civil cases.
I think you may have said it both ways, so just to clarify,
No.
the hidden camera can or cannot be used civilly?
Cannot. The open ones
thank you.
can. The open ones can be used civil, administrative, or criminal.
Thank you, Mr. Chairman.
And there's nothing to keep the family from having both going at the same time. And if that was the case, if there's something going on, they could also catch it on the open camera, which could then be used.
All right, Senator Hatchett and 10 right in front of you there, Chair Lady Cooper.
Thank you, Mr. Chairman. My question is with respect to cell phones, and one of the witnesses testified that cell phones were not included. I guess this is a two-part question. Could you help point me out where that section is that would not include a cell phone? Because my understanding that electronic monitoring device means a video camera or an audio recording device or a combination thereof. I think that encompasses a cell phone, and that just, I'm worried that
Leah?
if you could help me understand that
Okay,
a
because
little better.
that was, we didn't exclude them in the first one. They just it wasn't obvious for the state's ombudsman at the time. It was never our intent to, you know, exclude the use of those, because it's just like the big decubitus ulcer. One of the easiest ways to see a decubitus ulcer without exposing the patient would to, you know, turn the patient, usually they're in the coccyx area, and to take a picture of it on your camera. So where is it in the? So if she may, Leah may.
Good afternoon. Thank you, Chairman, for allowing me to address the committee. My name is Leah Aldridge. I'm a member of the Georgia Bar, and I'm also a licensed health care provider in Georgia. So we defined authorized electronic monitoring on line 8, beginning on line 18, to mean the use of a device to monitor the resident or activities within the room in accordance with the article. So if the device is being used to do something other than monitoring the resident, like watching Netflix or having a FaceTime video call with a care provider, it falls outside of the entire scope of HB 605.
You want to follow up, sure.
If I can, Mr. Chairman. So my understanding is the authorized electronic monitoring would not include a Zoom call, even though that is a video call with a camera in a room. That's what the intent of this bill was to not include that.
Right, if you're having a Zoom call with a family member?
With a family member specifically.
Correct. So if you go down to line 34, before initiating authorized electronic monitoring, which then refers you back up to the definition, which would mean the use of a device to monitor the resident.
All right, Senator Kirkpatrick.
Yeah, I just have one question. I'm confused also about the hidden camera issue, and I'm looking at lines 83 and 84, where it says, "No person shall conduct clandestine use of an electronic monitoring device to monitor a resident's room unless otherwise authorized by law." Can you just square that up for me?
On 82 and 83? Yeah, it's on 82 and 83.
Could you repeat your specific
83
question,
and
Senator
84.
Kirkpatrick?
I
Yes.
didn't understand it.
So this bill is about open cameras. Think about it that way. And we do provide at the end of the bill that there's what we might call the use of, if a family wants to put a hidden camera in, that any recording from that camera may be used in criminal proceedings. So line 83, when it says you shouldn't use a hidden camera unless otherwise authorized by law, the use for security reasons or if you suspect criminal activity is otherwise authorized by law in the criminal code. And I can give you that code section. It's code section 161162.
So that's
2.
Yeah, that's lines 255 through 259. So, gotcha. Okay, so it refers back there. Any other questions? Senator Cowser.
Any particular reason why you would not allow
these to be admitted in a civil action as well as a criminal action? I'm back to your lines 256 to 259.
On the hidden camera, Senator?
Right.
And it was just a policy decision in trying to not have the got you, but to encourage families to go to the out and open ones to prevent the kind of things that we've seen happen. I truly believe that Mr. Dempsey's and his father would probably be alive or would have had a chance to live if there had been an open camera in that room and a note outside the door that there was a camera there. I do not believe those people would have acted as they did and ignored his pleas for help if they knew that they were being recorded. But because they didn't know, they acted in such a hideous way that they caused his death. And personally, I'm not a lawyer, and I guess, and I'm not going to be on the jury, but I hope they throw the books at him. But I do believe that he would have had a chance for life. And so it was a policy decision to try to be out in the open, just like we are with watching children in daycare situations, or some of the adult daycare places have it out in the open.
So what the effect is, though, you're holding them responsible in a criminal process where they might go to prison, but you're not holding the wrongdoer or the facility that's accommodating it civilly responsible for damages that they cause to the patient. The distinction, it's just, you ought to be asking for both if that's your objective, is to hold wrongdoer accountable. You're limiting their accountability to criminal prosecution only. Not being responsible for damages to the plaintiff that they may have caused.
Okay, Senator, I'm respectful
That's all.
of your.
It just seemed to be intentional. I was wondering the thought process behind it.
No, not in, other than to push for it to be out in the open.
This is just a very short follow-up that follows on Senator Cowsard's point about it being only criminal liability. And I think one of the people who testified noted that this only punishes the staff and not the facility. And I wonder if that's always appropriate, because sometimes, first of all, you had mentioned that the staff tend to be overworked, low-paid, all this kind of thing. And sometimes facilities do promote a culture where, through no fault of the staff, that maybe if they're understaffed, that they can't turn a patient every 4 hours or whatever they're supposed to because of a facility oversight or because of facility under-resourcing their staff. So I wonder if that leaves bare, like it hangs the staff out to dry even when it's not necessarily their fault for neglecting the patient. Do you think that's a risk?
Well, I think the thought process is what you said earlier, is that an open camera does promote better health and better outcomes, and rather than a gotcha, so to
Right,
speak.
and that's
I got you.
I'm a nurse.
I understand, right. I understand.
I just had a
Dr. Hunter.
follow-up, Mr. Chair.
Yes.
I think I found the answer to the question in that code section that you referenced, where it says, unless otherwise authorized by law, on line 84. That code section includes security or crime protection.
Correct.
So to me, that would imply that those cameras are allowed under this bill?
Yes. Yes.
Okay.
All right, thank you so much. We're getting close on time here, and we got 3 more bills, so I apologize to going on so long, but I will have the will of the committee here. Do I have a motion? Motion, Senator Burke. It looks like 11.
House Bill 605, 338801S.
It's by substitute, House Bill 450, I'm sorry, getting ahead of myself, 605, thank you, by substitute. Do I have a second? Second, Senator Kennedy. Further discussion? All those in favor, let's raise our hands on this. All those in favor? 1, 2, 3, 4, 5, 6. 6 in favor. Did I count that right? All right, all those against? 1, 2, 3, 4, 5, 6, and the chair breaks the tie, 7. So this moves on, this passes. 6-6, and I broke the tie to make it 7-6. So this will move on to Rules Committee. Thank you, Chair Lady Cooper. I'm sorry that, hopefully that didn't wear you out. I know, yes. She has two more, so apologize. So we're now at House Bill 458. That's in your folder. 458 and LC 338801S.
Ready to go?
Yes.
Thank you, Mr. Chairman. The medical board, the Georgia Medical Board came to me and asked me to move this bill. As you know, because of all the cases of inappropriate sexual activity in the press these days, from People Magazine to the New York Times, of things that are going on, and the case like the doctors that up north that were in charge of all those young athletes and took advantage of them. There's a big movement to crack down and be more specific and educate doctors about sexual boundaries. If you notice, many of our doctors, including the ones that serve here, are distinguished with a little bit of gray in their hair. And with times when not realizing perhaps a word would be offensive or so this bill moves to correct that. The first part of the bill in Section 1 was put in by Senator Kirkpatrick, but came out of something and some concern on the Senate floor that dentists should also be included in this area. What it does in Section 2, it's promoting a greater understanding of sexual boundaries and implicit biases. And in Section 3, the board has always had the ability to remove a person's, to suspend a person's license, even if they have not been found guilty on a criminal case, if the board thought that they had stepped over and acted inappropriately with on sexual issues. However, it was not in the law. So Section 3 puts the board's ability to suspend a license into the law. Section 4 is going to require that physicians would receive a one-time educational training of a minimum of 2 hours regarding professional boundaries and physician misconduct. It also says that the board members also will take training so they know more about it. And another one is that we will include it after June 2022, that our medical schools in our state will also work it into their curriculum. And the end part in Section 7, one of the problems in the case is that is that people and the physicians that were in mind, they knew that these young people were being sexually exploited and did not report it. And so what the board has done is put in defined sexual assault and has put in a pretty severe punishments if a physician knowingly knows that a colleague has sexually assaulted a patient or has overstepped the boundaries and they do not report it to the Board of Medicine. And that basically is the what the bill does.
Thank you, Chair Lader. Any questions from the committee? Senator Jackson.
Thank you, Mr. Chair. Madam Chair, thank you for being here today. In Section 1
Yes, sir.
of, isn't it already in code when it comes to dentists, practicing dentistry?
Could you ask Senator Kirkpatrick that question, Senator?
Madam Chair, isn't it already in code?
For dentists.
Actually, I talked to the dentists at length about this section, and they were fine with adding this specific language.
Sliding in behind you
And
is
sliding in behind is the,
a lawyer and a representative. Do you mind,
I've been on board.
Mr. Franco? Yes. Dental Association.
Thank you, Chairman Watson, members of the committee. My name is Scott LaFranco. I'm with the Georgia Dental Association, the General Counsel. I kind of heard something about the Dental Act, so I just wanted to come in case you had specific questions.
My question is, sir, isn't this already in code?
It is. It's not in code. It's actually in the board rules. So what we did is, at the request of Chairman Kirkpatrick and Chairman Cooper, in response to that floor amendment that happened on Senator Kirkpatrick's Senate Bill 5, we worked with both chairs to incorporate this language. And in fact, the part about legal ethics and professionalism, the Board of Dentistry actually adopted a rule back in February of last year on this. However, we've been waiting on the governor to sign off on it, so
Okay.
that's where we got this language.
Thank you so much.
Thank
Any other questions from any committee members? If not, the will of the committee. Do pass Senator Walker, Huffstetler for second. We're going to do this by voice. All those in favor say aye. All those opposed, like sign. Pass unanimously. Thank you. Yes, okay. You know what? I was rushing a little too fast there, so we are just past. Let me make sure I'm clear. Right. House Bill 458, LC 33875S 857S by substitute passes unanimously. Thank you. Yeah, and Chair Lady Cooper, did we have who was carrying your first bill and who was carrying your second bill?
I think Senator Kennedy is carrying the first one, 605.
Okay.
And that Senator Kirkpatrick is carrying the 530, not
Okay.
539,
What's next?
the other one, 458.
Okay, and then we have House Bill 539, and we have a substitute coming in on that, and Ms. Kendrick was going to speak for you on that.
Thank you.
There's that piece of it. Take that out of my way. All right, the floor is yours.
All right. Thank you so much for having me today. My name is Stephanie Kendrigan. I'm with MAG Mutual Insurance Company. We represent about 7,500 physicians and healthcare providers here in the state of Georgia. I'll be very quick because I know you've got regulated industries coming up. But one of the things that we're constantly looking at is how we can improve the medical malpractice trial process. And we're constantly looking for best practices across the United States. And one of those best practices came to us from the state of North Carolina, where the North Carolina Medical Society a few years ago did a thing called trial bifurcation in med-mal cases, and they did it in 2011, and we've seen significant success with that. So in Georgia, the way to think about trial bifurcation is we really already do this in criminal cases. You think, first of all, you determine whether or not that defendant was guilty or not guilty, and then if you find them guilty, that's when you enter the sentencing phase of that trial. Trial bifurcation for a med-mal case would be exactly the same. First, you would determine whether or not that healthcare provider was negligent in their duty of care to that patient, and then if they were negligent, that's when you enter the damages portion of the trial. We believe this would save, and what we've actually seen in North Carolina is it saved us 2 to 3 days on a trial, which right now would be significant considering we have a backlog in the court system due to COVID. So any savings that we can offer the court system, we think is a public policy benefit. And then also, quite frankly, when a physician has a trial for medical malpractice, that can be tolling on them both emotionally, physically, and any speeding up of that trial that we can do helps that physician get back to their practice. Finally, I think that, the bigger public policy point is that, quite frankly, medical malpractice cases can be incredibly complicated. You're talking about, difficult medical procedures. There's a lot of expert witnesses. There's days and days of testimony. And to try and conflate the issues of the damages versus the actual negligence can be both confusing for the jury and, quite frankly, prejudicial. So we would recommend passage of this legislation. I believe you probably have in your packet a letter from all of the healthcare provider groups that are supportive of this legislation this year. And I'm happy to answer any questions, but we would ask for your favorable consideration of the legislation.
Any questions? Senator Hatchett.
Thank you. I just have one question with regard to North Carolina. I know they're joint and several. I've done a lot of research on this issue. I think the spirit is good. I don't think in a practical manner you can do a bifurcated trial and ask a jury to apportion liability for damages if the damages aren't presented. So would you?
Yes.
Well, I was going to say, would you, to make this work so you're not putting a round peg into a square hole or vice versa, would you be open to amendment to allow joint and several liability in medical malpractice cases?
No.
Okay.
And the answer to the question, I believe, would be that you would actually apportion, the way that it would work is you would apportion the fault during the negligence phase of the trial, and then that would be used to apportion the actual damages once you got to the damages portion of that trial. That's how that would work here.
Any other questions? If not, I stand at the will of the committee.
Mr. Chairman, I'm Dan Snipe from the Trial Association. I didn't realize this would be for me to substitute on this bill. I asked to have myself first.
We'll give you a couple minutes, sir. Yeah. If you just repeat your name for Mr. Beal, please.
Yes, sir. Thank you, Mr. Chairman. I'm Dan Snipes. I'm the past president of the Georgia Trial Lawyers Association, and I practice law in Statesboro. Currently, OCGA 91141 gives a trial court judge the discretion to bifurcate any trial between liability and damages. That's something that's available to any party now. And trial judges, our elected trial court judges, have the ability to decide in each case if judicial economy would determine that that's a wise decision or not. My understanding of the language, and I've not seen the language, but a similar bill was introduced earlier and did not pass out of the Senate Judiciary Committee. But this is asking a judge to go through and require certain findings. It's our position that the current statute already gives the judge this discretion. This type of bill, though, would not save money for anyone practically. The cost of preparing for a trial is in the preparation part. And the damages portion of a civil trial, whether it's a med-mal trial or any other trial, is a relatively small portion of the trial in comparison to the contest over liability. And when you spend the money to prepare for the liability portion of the trial, whether you're the plaintiff or a defendant, that's where you spend your time and money. That's where experts are. But particularly in med-mal cases, because of the complicated issues of causation, and causation is part of liability. You have to prove a breach of the standard of care and a cause. The causation experts are also often the people that testify about damages. And in the context of someone that has a surgical procedure, develops a deep vein thrombosis that becomes a pulmonary embolism and then causes a stroke, you have to have someone to describe the causation. How did the stroke occur? That's part of the liability. And a lot of times in complicated medical cases, complicated injury cases of any sort, it's almost impossible to separate the causation element from the damages element because you have to talk about it. And the same experts would be called back to testify for both sides in both portions. This bill does not do anything to promote judicial economy. It just doesn't.
We
That's the
appreciate
reason
that. Thank
I'd
you.
ask you
Thank
to
you, Mr. Snipes.
vote against it.
Senator Allred.
I wonder, you may be able to shed some light. You said this was in Senate Judiciary before?
Yes, ma'am.
Right, Senate Judiciary, I think I'll answer that. Yes, it did not pass. It was really close, and it did not pertain to medical malpractice, and this is a little bit different.
Why are we doing this in the Health Committee?
Well, it's medical malpractice, and I chose to. Any other, Mr., do you have any other questions?
There's one more.
No, you.
Yeah, I have one.
You have
just
one
more.
question. Okay, thank you.
Because we are an apportionment state, if the judge shall order bifurcated trials upon the motion of either party, in your opinion as a lawyer, would it not be considered legal malpractice not to try a case in every circumstance, which would lead to higher insurance costs for doctors?
And Senator Hatchett, I have not had an opportunity to review this bill. I did not understand that this bill actually had a shall language, whereas the judiciary bill that was defeated was a discretionary type. I didn't realize this was a mandatory bifurcation. And Senator Orrick, I'm sorry, I've not had a chance to see this substitute. Senator Hatchett, to answer your question, I think that if you bifurcate, if everybody can ask for bifurcation every time, you're going to have more trials because you're taking away an incentive of both parties to try to resolve a case prior to a trial, meaning that if you can have a free bite at the apple, that you get to try the case as to liability only by asking for it without being any exposure to damages at that case, I think you take away an incentive for parties to settle cases, and you're going to have considerably more jury trials, costing considerable more litigation expense, and
Thank you, Mr. Snipes.
okay.
All right, we'll go with will of the committee here. Have a do pass from Senator Kirkpatrick, second by Senator Burke. Any further discussion? All those in favor, let's raise our hands. 1, 2, 3, 4. Did I get that right? Let's do it again. 1, 2, 3, 4, 6. I'm sorry, I was about to miscount there. So that's 6. All those against? 1, 2, 3, 4. Did I get? Let's put those hands up again. All right, I'll tell you what, I think I made a mistake the first time. Let's count, all those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7. I apologize, I miscounted. All right, all those against, raise your hand. 1, 2, 3, 4, 5. The motion passes, and that was House Bill 539 by substitute. Yes, do we have a carry on that one? We'll come back to that. And I'm going to ask the discretion of the next committee chairman whether or not you will allow us. I'm totally flexible for House Bill 653. Chairman Calzert, I think it's going to be a real quick bill. I think it's going to take. Okay. Is Representative Jasper still here? He is. I apologize for me running over time. That's a reflection on me and not on anybody else. And I apologize to the regulated industries. If you don't mind being brief, this is not a controversial bill.
Ready to
floor is
go.
yours.
You know, thank you, Senators Committee. I bring before you the House Health Committee substitute to House Bill 653. It's LC 338745S. It's very simple. It allows our pharmacists to continue to offer COVID testing for COVID-19 and serology. That's the antibody part. And the interpretation of the results for 12 months after the public health emergency is ended by the U.S. Secretary of Health and Human Services. That's all it does.
Any questions? It extends the amount of time the pharmacists can do testing from 12 months after the end of the pandemic.
Yes, sir.
Orders of emergency. Yeah, we don't know. Senator Burke's raising his hand. I hope for a due pass. It is. Do I get Senator Walker raised his hand, and we'll go with him. And all those in favor say aye. All those opposed, like sign. That one passed unanimously.
Thank you. Thank you, Committee.
I apologize to Regulated Industries. Thank you, Chairman Calzert, for letting us finish that one. And thank you for your patience, Representative Jaspers. And do we have anybody that's going to carry that bill?
I think Senator Hustetler is.
Chairman Hufstetler, and we're meeting tomorrow at 4 o'clock. So thank you so much for being patient today. Meeting adjourned.